I've been taking my time, taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. We got greetings, we got announcements, and we got this YSL Trial. Can y'all hear me? Just making sure. Soundcheck Annette says yes. Okay, Gigi was first in the building. Gigi said they just need to let him go at this point. Hey, Flower Bloom. Hey, Kat. Hey, Ann Green. Wandy, welcome back because I know you've been a member before. Hey, Wandy. Hey, Bonnie Mason. American Born, number 9 with the likes. Thank you. Hey, Soundcheck Annette, number 10. Charlene Matthews. Leah's grandma, number 14 on the likes. Thank you. Miss E. Barstar. Hi. Chi-Town is here. Okay, so you over there with, you from like Big Sis Chit Chats from Chi-Town. Okay, Dawn Michelle, Chi-Town. Hey, Kim Jones. Hey, April with the 2 L's, number 3. Okay. Hey, La Tigre. Let me see. I'm going to go down. TD Love. Hi. You said number 12, not number 3. Got you. Hey, Ebony Dancer. DG. 22 for my 22. Okay. I like it. Okay. And hey, Shirley Macklin. How are you doing? I'm going to get into some announcements because I do want to talk to you about a couple things. First of all, congratulations again to Melody for hitting 3 million likes. She's probably closer to 4 million and 3 at this point. But congratulations to Melody for hitting 3 million. She went up a million. Like the Millimeters fan page posted a milli. It was just popping. I love to see it. Happy for her. That's awesome. If you didn't get to see me do a review on her travel pack scents, because there's 2 new scents. Whoop whoop. Coconut vanilla is mine right there. That's my baby right there. Please watch that if you didn't get to see it, so you can see my reaction, because I had not smelled I hadn't even smelled strawberry before, so some of them were new to me. The Millimeters fan page said all they could hear in their head was when I leaned to the side when I smelled that Coca-Cola. Oh my God, when I smelled that coconut vanilla, they said she said all she could hear in her head was that Usher song, that "There Goes My Baby." And I'm like, that's in my head now, because when I tell you the euphoria I felt when I smelled that coconut vanilla was unreal. So yes, I'm like, that's so appropriate. Also, Sunday's coming right around the corner again. And I don't know what y'all doing at 7 p.m. Eastern Standard Time on Sunday, but I know where you should be. And you should be over there with me and 41 Fit for our House of the Dragon review. Let me give you a little taste, just a little bit of something. We had a special guest last Sunday. The OG is not strawberry. Which one's the OG? DJ, you gotta tell me. Did I get it wrong? My bad. I thought the OG was strawberry. But look at here's a little snippet of 41 Fit here for hot tea and myself with the House of the Dragon review. Is not gonna be long. I'm just giving y'all a taste so you can know. Okay, and that's where I should see you on Sundays. Get your life on Sundays, right?
I am so annoyed by her very presence. Everything about her aggravates me because this entire war is based off of jealousy and greed, ultimately. In my opinion, granted, the High Towers do have a decent name, but like she hasn't come from the same royal background as Rhaenyra. So when they were younger, she was so gun-ho on trying to be a part of, whatever it is that she felt Rhaenyra had that she ultimately wanted. Like, let's be honest. And so she basically ruined her friendship with Rhaenyra, judging her for wanting to live in her truth and not really wanting to be limited to what her name and what being a part of a royal family entails, right?
Okay, I'll keep it there in case some people come in like, I thought we were watching YSL, but yes, we had our wigs. We are Targaryen, Valyrian over here, okay? We are, what did she say? Oh, 41 Fit. I don't know if you watched this episode yet of this week. Sis, put in the chat if you watched it so I can say our line if you did watch it. Because that was a cold line from Bayla. Oh, okay. Hey, y'all. Hey. Oh, you got on early? I can't ever get on early. What am I doing wrong? I don't know, Avis. I don't know. Okay, so when she said, I am a fire and blood, not salt and sea or whatever she said, I said, oh, or salt and water, salt and sea. I was like, oh, we are fire and blood over here, 41 Fit. Okay. So please join us on Sundays. Okay, let me go ahead and move on. Do I have another announcement? I've been getting questions about the wig. So I did reply to somebody in the comments. Muted Expressions, and someone else I think asked about the wig. But I did the whole wig review in its own video. So go check that out if you want to see where I got the wig from. But the wig is growing on me every day. It is, because y'all know it's flatter than what I'm used to, but it's growing on me every day. Tomorrow, we're gonna go over Kevin Hart's friend suing him for not, I guess, clearing his name in the SEX tape extortion thing that happened. So his friend is suing him, JT Jackson, I believe his name is. We're gonna read over the lawsuit. So I want to thank the Trendies for sponsoring this court document, because I did have to get this one on my own. So I want to thank you in advance. We're going to go over his complaint against Kevin Hart. The lawsuit opened in 2024. I'm going to play y'all something from 3 years ago of how he seemed like he was feeling about Kevin Hart at that time. And then now, of course, we have the lawsuit. So, so please come back tomorrow. That'll be our lunch break live tomorrow. We will do Kevin Hart's the next lawsuit. Now he's a defendant. The other one, he was a plaintiff against Tasha K and his former assistant. I'm trying to change my background. Let me see here. There we go. Okay. All right. So let's get started with, we're going to look at the articles that came out with these judges. And I was like, because I came prepared to just say, hey, this is who replaced Glanville. But then they're not the judge on the case anymore either. So let's go ahead and start from when Glanville was removed. Okay, so it says this was July 16th, Okay, 2 days ago, July 16th, 10 in the morning, it says a new judge has been assigned to take over Young Thug's internationally watched criminal trial in Atlanta. According to the Fulton County Superior Court, Shukura Ingram is an appointee of former Governor Nathan Deal, who won re-election in May after running unopposed. She served on Fulton County's Magistrate Court from 2015 to 2018. She holds a bachelor's degree from Clark Atlanta University and a law degree from Georgia State University. Ingram has also been a senior associate with Thomas Kennedy Sampson and Tompkins, a College Park-based law firm, advertises itself as Georgia's oldest Black-owned law firm. She has also worked as a senior assistant district attorney in the Fulton County District Attorney's Office. Ingram takes over a trial that has already surpassed Georgia's longest jury selection process, and one is that rapid. I think they did that a little backwards, and one that is rapidly approaching the state's longest in history. Okay. So, where did it go? Okay, so this, first of all, should be the order on motions to recuse Judge Glanville. So we're looking at that first. Okay. And then we're going to get onto why we don't have Judge Ingram anymore. Okay, so it says order on motions to recuse Judge Glanville. And that was the first judge, the male judge that, if y'all are following, y'all know who that one is. It says this case is before the court to consider various motions to recuse, including defendant DeMonte Kendrick's motion to recuse Chief Judge Ural Glanville, Kayla Bumpus's motion to quash the show cause order and or to recuse Judge Glanville, defendant Jeffrey Williams' motion to disqualify/recuse Judge Glanville from all further dealings in the above referenced case, and amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable law, the court finds as follows. I'm going to make this bigger. Okay. So, findings of fact. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. The motions to recuse all arise from the same circumstances related to the state's witness, Kenneth Copeland, or Lil Woody, as most of y'all know him by. On June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court, and just to keep the names in order for y'all, Mr. Melnick would be Lil Woody's attorney and Copeland is Lil Woody, and reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m., and court was adjourned for the day. On June 10th, 2024, at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state who had joined the meeting. So Simone Hilton, counsel for the state. Okay. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, defendant Williams's lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. And Brian Steele is Young Thug's attorney. Williams is Young Thug. Mr. Steele objected to the ex parte meeting and a lengthy. I'm not sure. I feel like there's. I gotta look up this word. Hold on. I'm looking up a word, y'all. 1 second. Colloquy. So a colloquy is a conversation occurred between Mr. Steele and Judge Glanville in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by Diamante Kendrick on June 12th, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertions of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. On June 14th, 2024, Kayla Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17th, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from his hyperbole, Mr. Williams's motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams's motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville I lost my place. And Judge Glanville became embroiled in a controversy when he held Mr. Williams's lawyer, Brian Steele, in contempt. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and the witness, who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. Okay. And we're almost done with this document. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice toward the moving party in particular, or a systematic pattern of prejudicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. And from what I understand, the moving party is whichever party filed the motion. So, like, since Attorney Steele filed a motion, he would be the moving party for this part. That's how I understand it. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, i.e., the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person rather than the affected judge or other interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. Okay, so Judge Glanville would not have been able to respond or refute the allegations because it's already assumed you deny the allegations automatically. Okay. All right, DG. I'll see you when you if you get to come back or if you catch the replay. It says a judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. Ooh. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. So basically, the judge cannot try to bring up a defense for recusal, because if they did that, they're saying, obviously, I think this person is really wrong, and I have to defend myself. And then if like the recusal is denied, meaning Judge Glanville could have stayed with the trial, he definitely would have an adversary with Attorney Steele, because Attorney Steele and other attorneys were telling him he should have recused himself. So I do see where they're coming from with that. So analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Sorry, I gotta clear my throat. Hold on one second. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. So should he not have opposed the first motion then? Because even in this document, it says at first he said it was insufficient and they're not moving forward with the recusal. So was he not supposed to do that either? Because that's what that sounds like. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. So the judge that's overseeing this recusal, is saying that they don't see anything improper with the ex parte meeting. That's what this judge is saying. She says, while the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. So all that long-winded stuff when he was saying why he would put it on pause, or no, the first time was it? No, yeah. That was his long-winded one when he was reading it, and then he did put the case on pause, but he did cite his defense. It seemed like to those that were watching, we were like, "Oh, he's putting all his defenses in here before he rules on the motion." It looks like, and they're saying you can't do that because that's you providing this defense, and judges shouldn't, because they're just there to be over the trial and be unbiased. There's no reason for you to defend because you could just go on to the next case, is what it sounds like. So he powed himself in the foot, I guess, with all that extra defending that he did when he did it on a couple weeks ago. So it says, this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. So they're saying that he wasn't improper. Right, DG, he was doing the most. Exactly. They're trying to say he wasn't improper, but he still told the line on how he defended himself. And so, and the public's interest, the public's confidence. So that's why they're letting him, he has to recuse himself. So it says, based on the foregoing, this court hereby orders as follows. Defendant Diamante Kendrick's motion to recuse Chief Judge Ural Glanville is granted. Kayla Bumpus's motion to quash the show cause order and or to recuse Judge Glanville is denied as moot. So basically, it doesn't need to be quashed. I think it wasn't going to happen anymore. So that's why they're saying it's moot for Kayla Bumpus's motion. Defendant Jeffrey Williams's motion to disqualify recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignment procedures. It is so ordered this 15th day of July 2024. So that's when we officially lost Glanville, right? So now we're going to get into Judge Ingram and how we quickly gained her and quickly lost her. Bonnie said he was trying too hard to stay on this case. DG said the key phrase is avoid the appearance of impropriety. Yeah, I agree, DG. I agree. Hey, Tia P. Okay, so let's look at Shukura Ingram's, like, just a little bit of her history. So I'll try to go. Hold on one second. Let me close my door. You know, black people, I don't know if y'all heard that audio, but you know, when black people get on the phone, they start getting extra loud. I do it too. And that's why I had to close the door because Mr. Trent is getting on the phone. And his voice is just going whoop, 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 up and more. Okay. So it says judicial assignment. 2015 to 2018, she was a magistrate court of Fulton County. In 2018 to present, she's been assigned to Superior Court of Fulton County. Education, Juris Doctor from Georgia State University College of Law, a bachelor's from Clark Atlanta University. Professional experience is, okay, we're going to go through not all this. Hold on. Y'all, I thought I was going to read this. I'm not reading all of this. I love it for her. I love an accomplished black woman. I do. I'm just not going to read all of it. So I'll give the first four bullets. That we'll say those are her most important ones. They're right here. So Senior Associate Thomas Kennedy Sampson and Tompkins LLP, Senior Assistant District Attorney Fulton County District Attorney's Office, Assistant Solicitor City Court of Atlanta, and Master Bleckley Inn of Courts. Okay. So this is her though. So you can see her picture. That's Judge Ingram. And we're about to get into why she recused herself. So we're going to move on to this one. Okay. So this says hours after Fulton County Superior Court Judge Shukura Ingram recused herself, less than a day after she'd been assigned to it, Judge Paige Reese Whitaker was named the trial's new jurist. Ingram had been assigned to the case after another Fulton Superior Court Judge, Rachel Krause, ruled the trial's first judge, Superior Court Chief Judge Ural Glanville, should be recused. Okay, let's get into her recusal that she filed on why she cannot remain on this trial. Extensive resume, Bonnie. Yeah. Well, actually, now the reason for her recusal, when I read the summary, that's not what it was about. That's what I can say. I'm about to read this actual recusal though. It's only 2 pages. It's quick, but we're gonna see why she recused herself. So, order of recusal. It says on or about June 1st, 2023, Christian Eppinger, one of 18 defendants, was severed from the ongoing YSL RICO trial on the criminal action that was recently transferred to this court for random assignment. Although there is no severance order in the record, the court was apprised of the circumstances that directly led to Eppinger's severance. More specifically, the deputy assigned to and responsible for the courtroom and personal security of the undersigned for nearly 6 months was arrested. Okay, so there was a deputy that was assigned and he was arrested. Said deputy, who was still assigned to this court at the time of her arrest, is accused of 1, colluding with defendant Eppinger during the current trial to commit a felony, and 2, endangering the safety of citizens within the Fulton County Courthouse. Because this court's former assigned deputy could be called as a witness in any future proceedings in this case, the court may be called upon to assess this deputy's credibility, the court being the judge. or rule on matters related to her criminal prosecution. This may undermine the public's confidence in the impartiality of the proceedings. While the court does not regard the aforementioned situation as creating any actual bias for or against any party to this case, the court does view this as a matter that could cause a reasonable person to question the court's impartiality and reasonably give rise to the appearance of impropriety should the court remain on this case. Rule 2.11 of the Georgia Code of Judicial Conduct provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Commentary 2 to that rule provides that judges should disclose on the record or in open court information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if they believe there is no legal basis for disqualification. Thus, after careful consideration and consistent with CJC Rule 1.2a, promoting public confidence in the independence and impartiality of the judiciary, and CJC Rule 2.11a, requiring disqualification when the public might reasonably question a judge's impartiality, the undersigned hereby recuses herself from this criminal action. The clerk of court is directed to reassign this criminal action to another judge, so ordered. This is yesterday, the 17th day of July, 2024. Okay, so that was why she recused herself. The deputy she was aware of having an improper relationship. Deputy was arrested and could be called as a witness, and so therefore she's like, I can see how I could be viewed as not being partial anymore. So okay, so I guess she would have had to have been involved. An assigned deputy she would have had to have had prior knowledge, I guess, of that, and that I think maybe the deputy was assigned to her courtroom or something. So I'm trying to make sure I understand the connection all the way. Let me see. I'm trying to see what they put in the article. Yeah, Ingram wrote that Stanley had been assigned to her courtroom at the time of the alleged relationship. So yes, okay. Bonnie said, wow, right. Hey, Teresa, trending. So check your Cash App when you get a chance. I had my granddaughter send something since I don't have Cash App. I think, did she send it earlier before I went live? I tried to send an emoji back if so, and I thank you very much for my Cash App. And Bama Girl, oh no, I think this just happened. Hold on. Let me see. Oh yeah. Okay, it just happened. Thank you very much. We haven't played our all right. We haven't played that in a while. So I'm gonna go ahead and say thank you to Bama Girl, to you, to Miss Lady One. I appreciate y'all. Hold on, let me gotta pop the trunk.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Thank you very much. I appreciate it, because with this new Kevin Hart case, then I heard Kenya. Well, I heard it from Chit Chat. That Kenya and Claudia are suing a YouTuber called Michelle Atalian. So I probably would want to read that if I can see it. So I definitely appreciate that, because we do have court documents I want to go over. Put my banner up. So thank you. Court document. Now, obviously not this one on the website, but the Kevin Hart one tomorrow, sponsored by the Trendies, and I definitely appreciate y'all. DG said she was like, I ain't sitting over no retrial of a case that already a year and a half into it. Right. They just gonna transfer their anger to her, DG. So I think she was smart in finding anything. I bet she was like, give me everybody involved in this case. Please, Jesus, let me have a connection to someone so I can get my behind out of here, because y'all are not going to do me like this. I'm not fixing this man's mess. DG, I swear that's what I put in my head. I was like, she don't want this trash. She does not want this trash. I am so here with DG on that. I agree. Hey, Peaches and Cream. Thank you, Miss Lady One. Kat said they are OMG. Cat. Okay, so now we have Judge Paige Reese, and I'll just show you her picture. And after this, we're going to look at, because apparently the lawyer said that there might be issues with Judge Paige Reese, or people have problems with her. Maybe there's not real recusal issues, but we're going to watch the lawyer after we look at her. I'm going to do the same thing. I'm going to read these first 4 bullet points under her professional experience, these top ones, and then we gonna go to the lawyer. I don't blame her either. SLX, I do not blame her. Bonnie said, I don't blame her. Right. No, she is not fixing your mess. No, get somebody else to do it. My sweet said, hey, Trinity, can you please do House of Dragons alone? Alone? No, not alone. That's me and 41 Fit. That's not a solo thing. That's me and 41 Fit. That's our baby together. That's our dragon egg. So I can't do that one alone. Kat said, I didn't know they were suing her. Girl, LOL, I just found out about Tasha. You missed one day and it's crazy. Wait, oh, you talking about the blogger thing? Yes. Kat, you miss one day, you do miss a lot. I found out from Chit Chat. I went to her live today, and had I not been in her live, still wouldn't have known, Kat. Would not have known. Shan said, yep, the defense gave her a fundraiser for her reelection. For this one that's on the screen right now, Shan? Everybody giving people money for their fundraisers. People have problems with her as code for she's too tough. I agree, DG. I agree. Bonnie said, oh, good Lord, move the trial already. Shan said, I would have taken it and dismissed in the name of justice. Shan, that's an option too. She probably didn't want no parts either way, but yes, that's an option as well, Shan. I can't say yes. It's been said they are suing her. No paperwork. Okay, no paperwork has been filed. Got it. Okay. Well, if it does happen, Shan, I need you, my legal eagle. Let me know. I'll keep my eye out to just go over it. But good to know. Keep me honest, Shan. Keep me honest. Okay. So let's go to the lawyer, and so I'm probably gonna skip up some, possibly, but I love his commentary. So I don't know how much I'm gonna skip up because I need to see his reaction to some of this news because I love seeing it from an attorney, obviously. And he's not new to YouTube. What else was I gonna say? This is a remix. I'm just providing critique, commentary. I'm researching and reporting. I'm not trying to pass off his work as my own. I am watching it to react to his thoughts on what we have gone over. Okay.
What's up, everybody? Welcome back in as we have more judge issues on this YSL case, maybe some unexpected issues as the judge that was going to replace Judge Glanville has already recused herself, and we have a new judge that's coming to the table, and we've got a lot of thoughts on her. A lot of questions have already come in about maybe some of her connections with some of the lawyers in this case. We'll talk about that. We'll talk about whether those are going to force her to recuse herself and whether or not any judge wants to touch this trial with a 10-foot pole. Make sure you guys hit the like button and are subscribed to our channels. Let's get into it. So I've got my dad on once again to continue to break down this case that has never said deputy who was still assigned to this court at the time of her arrest is accused of 1, colluding with defendant Eppinger during the current trial to commit a felony, and 2, endangering the safety of citizens within Fulton County Courthouse. What were your initial thoughts when reading that fact and those reasoning for her connection with this case?
Well, I mean, I thought that, if she wanted to, she had a reason to recuse herself.
No, I don't mean her reason for recusal. Like, that's crazy facts. Like, that's crazy that happened in this case. That is very abnormal for a deputy to be accused of colluding with a criminal defendant and getting arrested while still working for this court. That's crazy.
When I first read it, I had a suspicion, and later on in my research, it turns out. But when I first read it, I thought there's an affair going on here. There's a romantic relationship.
And that's what it is?
Yes. And the other ways it's been called an affair in a lot of the other documents or news reports that they were having an affair.
I mean, what is going on in Fulton County? I mean, this is crazy. So you immediately went there. You immediately went affair. That's what you thought.
Yeah.
Okay.
I immediately went to a romantic relationship.
Okay. So I didn't know what the connection was. I did not look into what the connection was. I figured her mentioning it. So that's also the criminal activity. Potentially that's what she is arrested for, some felony in regards to that.
They smuggled some things into him, did things like that. Now, and Eppinger, I don't have all the details of him, but apparently he's involved in stabbings and all sorts of things that occurred at the jail as well. So it's a bizarre group. Eppinger is apparently a very violent and dangerous guy, and he's having an affair with a deputy.
I mean, and this is literally like out of movies. I mean, what was the movie I was just watching where something like this happened? But it was a female inmate and a male guard. I can't remember what it was, and she ended up killing him and accusing him of something. But like this stuff happens in real life, similar to how it happens in movies or TV shows sometimes. And of course, it's going to happen in this case, because if it can happen, it will happen in this case.
Well, that's the point. You have movies that are written about maybe one of the things that happened in this case, but you rarely have a movie that would be written about all the things that happened in this case. It'll be just too complicated.
Yeah, you wouldn't believe it. If somebody like submitted the script, they'd be like, no, there's too much in this. Witness myself, or to call on the credibility of somebody I work so closely with regarding her affair and implication in this case that I'm now the judge on, that could obviously be problematic. And just to take it a step further, if this deputy goes to trial or, has a criminal case, it could never be in front of this judge.
Well, I got to be honest with you. All I can see is this judge taking a deep breath and saying to herself, thank God I found something that can get me off this case.
Well, I wanted to wait till
DG, Bonnie, Shan, everybody in here. I think we all were like thinking the same thing we thought. Like whatever that judge was looking like, whatever can get me out of this case. Shan said, "What happens? What happens in Fulton?" I'm waiting on something to minimize so I can see your comment. What happens in Fulton County Jail is actually not that uncommon. True. Shoot. The way that the inmates be talking about what they can get from the guards and everybody else. Yeah, I agree, Shan. It's probably really, really common. Bonnie said, yes, exactly. Somebody got to make the hard decisions and I don't mind. She didn't want it. She said, get somebody else to do it. TD Love said this happens in every prison. They be bragging about how it be happening too. You see the people on, y'all ever been on prison TikTok? I have not. I was like, I don't want to go that far, but I want my algorithm changing to put me over there. But prison TikTok, they be having takeout. Like they just chilling in there. Like, and it be different, different jails and stuff. It's wild over there. In South Carolina, we often wonder why some of these trials last so long in other parts of the country. Even Murdaugh's trial was 6 weeks. That's it? Shan said, I started my law enforcement career in a prison. It's absurd. The things you start to realize are going on. Ooh.
We got there. I don't want to jump the gun on that yet and talk about what could be coming in the future. But yeah, that's definitely one of the processes. But first, let's just focus on, legally speaking, what she's talking about in this order and her reasons for recusal and what we think about her legitimate reason for recusal, not what else we might think is going on, because we definitely share that thought, but I want to talk about it at the end.
Eppinger wasn't a party. Therefore, the deputy would not be called as a witness. So there wouldn't be any issues involved in this particular trial, the thug trial that we're dealing with. The issues she's talking about really don't involve the thug trial and wouldn't come up in the thug trial. So yes, she has a reason. It's a legitimate reason. She has a legitimate legal reason for herself for withdrawing and recusing herself. However, another judge could have looked at this and said, look, I can stay on this trial. I just can't do a trial where Eppinger is a defendant.
And so basically that's within this judge's discretion. So she made a call, and she made the call that even, to not have an appearance of impropriety, she is not going to provide over this case. And for me, it seems like a welcome change from how Glanville was handling it, but we're going to discuss the potential problems and why sometimes you need judges to push through and do what's right and be unbiased and be fair, even if there is a connection with 6 degrees of separation. Carrie said, Peter, could you please explain what recusal means? That means the judge is removing herself from this case. She is no longer the judge because of this potential conflict, potential ethical dilemma that may be presented to her, potential appearance of impropriety for the public, and loss of public confidence in her being a fair and impartial jurist on this case. So recusal just means you're getting removed from this case.
Also, interestingly to note that in Georgia, when a judge self-recuses, it's not appealable.
Which makes sense.
It does. So the fact that she recused it, that's the end of it. No one's going to appeal it. No one can question the recusal.
Rule 211 of the Georgia Code of Judicial Conduct provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. So as you can see, this is where she has the discretion, right? That, you're saying if she was harder nosed, she could have stayed on. If she really wanted to stay on, she probably could have stayed on, but she's not, and she didn't. It says might reasonably be questioned. And that's the big discretionary word there, is what's reasonable for someone for her to question her about this. She believes it is reasonable for her to be questioned. That's why she recused herself. If she wanted to go the other way, she could have said, it's not reasonable for you to question my impartiality on this trial based on what happened with Eppinger, and she could have stayed on, but she didn't. Commentary 2 to that rule provides that judges should disclose on the record or in open court information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if they believe there is no legal basis for disqualification. So she needs to put that on the record, regardless of if she was going to disqualify herself. She decided to put it on the record and disqualify herself.
If you take a look at that, interestingly enough, that really goes to the Glanville issue, right on it, because he was holding back information. And the rule specifically says that he's to disclose any information, even if he thinks there's no legal basis for the disqualification.
Yeah, which clearly he didn't. I mean, there's a million things that if you really want to look into like the rules of ethics and how we're supposed to handle ourselves that we can point to and be like, it's probably not how it should be done. Bodie said, just wanting to know jurors wanting to know what the heck is going on. I just can't imagine being a juror in this case. I think that the 4th of July was the week they planned to take off. And so now it's been another 2 weeks since then where they're supposed to just be sitting on their hands and not paying attention or trying to figure out what's going on. That seems impossible to me, but what do I know?
Well, it is. And, if we talk about mistrials, and I don't know if you want to talk about it now or we're going to talk about it later when we talk about judge.
Well, let's wait. Let's finish the order and then we can get into mistrials.
Okay.
Thus, after careful consideration and consistent with CJC Rule 1.2a, promoting public confidence in the independence and impartiality of the judiciary, and CJC Rule 2.11a, requiring disqualification when the public might reasonably question a judge's impartiality, the undersigned hereby recuses herself from this criminal action. Okay, so again, before we get to mistrials, because let's stay in order so people can follow where we're going. So this judge recuses herself. Has a legitimate reason. It was within her discretion. She could have stayed on, clearly, as you said. She decided not to stay on, which on one hand is a breath of fresh air that she's doing the ethical thing, staying away from conflicts of interest. But on the other side, you mentioned it before. So why don't you dig in now to what you think about maybe she was looking for a way out. Maybe she didn't want to be a judge on this case. What do you think about that? And how's that going to affect us going into the future?
Well, there's no judge will look at this and say, gosh, this is the kind of case I want to take. I want to sit in trial for 10 months and have all these arguments and go through all this without a break and, not see my family like I like to see my family. Because judges, frankly, they can control their own schedules, except for really when they're in trial. When they're in trial, they have to be there every day. So you've got a situation where she might not have wanted this case. She might have thought to herself, why would I want to put myself through it? She saw an out and she took the out. Again, I don't know that for a fact, but it certainly, could be a situation where she wanted an out and she found the out.
I don't think I can blame anyone for not wanting to sit on the bench and try this case as the judge. There's so much public backlash. They're going to be watching her, under a microscope. They are going to be jumping on every potential problem. There are also people asking, do you think she should have mentioned the donation from Glanville? Or do you think she left that part out simply because one, the reason was good enough, so there was no need to list all the reasons? So I'm going to hold this question, Dad, and we're going to talk about this a little bit more when we get to the new judge and talk about who supported her and donated to her campaign. And I've had a lot of questions come in about that as well. But
child, just stop donating to people's campaigns. Apparently, do not donate if you ever want to go through something without conflict. Apparently, do not donate to nobody's campaigns. Okay, so apparently Glanville also donated to her campaign, and then later, I know someone already said in the chat that the third judge the defense had donated to her campaign, which in itself is not, there's not something wrong. There's not something wrong, but it's like now there's a conflict because of how everybody's overlapping for this trial. Just apparently just don't donate. But she probably would have just kept that in her back pocket because she still didn't want to do this case. So I would have held it too just in case.
After reading this, my first thought was, oh, that's nice of her, conflict of interest. And then on second thought, I was like, wait a second. 18 defendants spread across multiple judges. Everyone's touched Judge Glanville in this case. Everyone's going to have some connection to a witness or a lawyer or a prosecutor or a defense lawyer or a public defender that has done something on this case. So if they all really recuse for any connection to this case, that could be very problematic. And we could end up in a situation where we can't find a judge now that can try this case. And therefore, do we have to change venue? And is that going to create an opportunity for a mistrial? And at that point, I start to think, is this really enough of a connection? Now, I think this story is crazy enough with what the bailiff is accused of doing, the fact that it was her bailiff, the fact that she obviously has some connection with that bailiff, that it was probably enough to recuse herself. That'll be different and interconnected enough that other judges won't really be able to be like, well, the bailiff in my case is the bailiff in that case. That's clearly not enough. So I do think that this was a little bit more than just your average problem that could create the necessity of a recusal. But it did make me start to worry about what's going to happen in the future. And now, whether it's this potential chance for a mistrial, Dad, or if you want to talk about the jurors now and if they're watching this and how many come into the courtroom whenever this trial starts back up, if this trial starts back up and they're like, actually, I did see something or I did read something or whatever it may be, talk about how all of this delay and dealings with the judges could affect a potential mistrial.
Well, some judges may look at this and say, and I think they should, frankly, look at it and say, there's just no way we can continue the trial with these jurors. How do you explain to the jurors this gap of time? Also, they've already heard Copeland testify partially. They've already seen that Glanville was the judge when Copeland testified. So now if during the trial, if it continues on, and you try to cross-examine Copeland based on his meetings with Judge Glanville, the jurors aren't going to know what happened to Judge Glanville. He's all of a sudden not there. This man that they respect and were told he is the neutral, they're not going to be calling him basically a non-neutral and a guy who went along with and was in cahoots with the prosecutors. How do you cross-examine and get a fair cross-examination of Copeland after all this? And how do you explain all this to the jury? There's no way to explain all this to the jury. It's impossible. I just don't think that it can continue on. I really think they got great grounds for a mistrial, and mistrials can be granted because of a manifest injustice. And the fact that a judge can say to himself, and I'm sure it would be a situation where an appellate court would certainly see that this is not your normal case. This is not the case that you see every day in the courtroom. And a judge is going to see, this just can't go on. I'm going to mistry it. It's nobody's fault. That's another thing which is kind of interesting. They're not going to blame the prosecutors for the mistrial. If anything, they're going to blame Judge Glanville for the mistrial. And therefore, that it'll be a mistrial without prejudice. With prejudice would mean they couldn't try him again. Without prejudice means they can still try him again. If they do a mistrial, they'll start this case all over again.
So I think that if they did a mistrial.
Okay, yeah. Okay, here we go. Because I know many early on, y'all was like, hey, at this point, it's a mistrial. Like, let's go. And of course, the defense attorneys asked for a mistrial as well. You have our our attorney correspondents weighing in saying that they believe this is great grounds for a mistrial. So we shall see. Oh my gosh. And I saw, because I had skipped ahead when I was pulling this video. It was some screenshots of something that the dad and son are going to bring up about something. And I think it's to do with Judge Paige Reese Whitaker, which is the third judge assigned to this trial, about some concerns that people had. So that's where we're heading towards that. But, we love a good background first. Yeah. Sweet Sis 41 Fifth said, come join us for future episodes of the Two Queens on the Throne. We thrive to make it an enjoyable experience for everyone. We hope to see you this Sunday at 7 p.m. Eastern Standard Time. Promote our stuff. 4150. TD Love said yes, a mistrial so they can get a new venue, new judge, new jury. This is too much. DG says, I declare a mistrial and restart. The judge, in my opinion, shouldn't have to start in the middle. How do they know what motions have already been heard and ruled upon by Glanville? Makes no sense to me. Ooh, okay. The only thing I can say is it must happen though, where a judge gets recused, but the trial still goes on. So what do they do in those cases? And maybe it matters how long the trial's going on if there's a recusal? Like, I don't know. Like Shan said, this seems like it's been a long trial, but it was mostly jury selection first. That's a lot.
The defense would be filing all sorts of motions for double jeopardy, saying that ex parte hearing was really the reason, blame it on the prosecutor. I think we're going to get all those motions to dismiss if this was actually declared a mistrial at this point. And they'll blame this delay on how they handled Copeland and all of that stuff. I think there's a pretty good argument they could point the finger at the state if it comes back to the delay because of the jury and they already started Copeland and he pled the fifth in front of this jury. I think they have a pretty good argument pointing the finger at the state as the reason for this mistrial, which then brings into double jeopardy and some potential dismissal options for them. I have heard, and I think some people told me an interview exists, I haven't seen it, with some of the lawyers on this case. And I don't want to say the wrong lawyers that were involved. I think
Weinstein, I think, said he was going to file a motion for mistrial and a motion for bond. Those are the two things I heard him say.
So, and he watches this, I believe. Somebody told me on Twitter as well. He may have been the one to say it. So, hello, Mr. Weinstein. Thank you for watching. So I also heard, though, that he and another attorney may not necessarily see this the same because they actually think they're winning the trial. And I don't know if it was him or the other attorney that said that, but they might not want a mistrial. They may not want this to necessarily go away because they think they're winning. They think this is good for them. And they think maybe the jury's picking up on all the craziness in Fulton County. What are your thoughts on that?
Well, first of all, let me say that a motion for mistrial, when denied, that's a motion that you can appeal.
Sure.
So that would be another delay in the trial, is appealing the double jeopardy motion. The other problem you've got is they might think they're winning. And if they don't file the motion for mistrial or motion for double jeopardy, and they lose, then they're going to waive the issue of double jeopardy and they won't be able to appeal it if they lose the trial. So it's a real roll of the dice, a real chance you're taking with your client's life if you don't move for that double jeopardy motion, if you don't move for that.
Have you ever known a good criminal defense attorney to not file a motion for a mistrial when there's even like the slightest possibility that they're going to get a mistrial?
No. And
good question, son to the father. He said, have you ever known a defense attorney that didn't file that motion for a mistrial if they even had a whiff of something? So I agree. I wanted to say this. I saw this conversation in the chat about this jury duty stuff. Cece, this is what happened to me. Cece said, when I do jury duty, I have to turn the check in to HR. We can only keep it if we're in a non-pay status during jury duty. Yep. They made, that was my first time doing jury duty. I had to turn the check in. Like, they was like, mail it to this, show this, put your time card as this. They did not let me keep my little $25 a day or whatever they gave me for the thing. I had to turn that thing back on in. So that's interesting, Cece. Yep. Shan said this probably won't move forward for a while. There's still some motions out there. Oh, okay, Shan. Thank you. Shan said most jobs don't pay for jury duty though. Y'all got good job. Oh. Well, thank you, Lord. I appreciate my good job. Yeah, because they sure did. They said, come on now. Come off the check. Not get to keep that. They said that quick. I was like, okay. I mean, thankfully it's like it wasn't a hardship to give them the check, but they sure made sure and check back with me to make sure I was sending them that jury check.
And also, I don't know a good one that won't file for double jeopardy under a situation where there is a mistrial.
Right. Yeah. So I think they're all going to file a motion for mistrial at this point, or I don't know about all of them, or if they'll join each other's or whatever it'll look like. But I think they will try I don't know if they'll be successful, but I do think it is something that they're going to try. A couple people have written in and said, Ashley said, Peter, there's a status hearing tomorrow with the new judge. All right, so maybe we'll take a look at that. Nick.
That's what Shan let me know too. Oh, Shan, is it 11:30 Eastern Standard Time? We still might have to watch it after it does it though, because I'm gonna have to skip the dead parts, because I was gonna say maybe that needs to be the lunch break live, but I might have to let it play and then we can go back and watch the status hearing together, so I can skip over just whatever, or watch them react to some of it and go over the best part. We'll see.
Said Judge Whitaker will hold a hearing tomorrow unless the prosecution wants her out. She is our new judge. So let's take a second to take a look at Judge Whitaker. So this is another person that a lot of people have been tagging me in a lot of their tweets, and seems to have very legit information. I don't know.
So I forgot to go over this. So since they're going to go over her history, great for all of us, because I forgot to read her professional credentials.
Them, so I can't personally vouch for them or anything, but everything I've read has been just kind of straight up saying what's going on. This Thugger Daily account, and he posted, "This is the new judge." Okay, what's really interesting about this judge is, so first off, he said, the judge, or this source he trusts, what's Judge Whitaker's reputation? That's who Woody just pled his last case with. So that's interesting. She has that connection to the case.
Oh, did y'all catch the first thing? Miss Lady One said she didn't have to turn in her jury check. Queen Common Sense, how are you? Where's my dab emoji, Queen Common Sense? How are you? Shout out to the content creators, 41 Fit, Queen Common Sense. I love to see you in here listening from the bushes. Yes. Okay. I see you. But okay, y'all. So they're saying that she just, how did they say it? Lil Woody just pled his last case with her. Okay. Lowest case count in the courthouse, efficient. Okay. So she don't be playing around with time, I guess is what they're saying with that.
Former head of the appeals with the DA's office, fair, maybe lowest case count in the courthouse, efficient. So if these two things are true, how does that affect the way we look at this judge as far as her ability to handle this trial?
Well, just a little background. Before she was head of appeals, the DA's office, she was in the appellate section of the Attorney General's office of Georgia. She graduated from Duke. So you're talking about someone here who is very smart on the law. Remember how we kind of complained that Judge Glanville was not real good on the law and made a lot of mistakes when he was doing the contempt on Steele, a lot of legal issues that he was having a problem with. Well, she's not going to have those mistakes.
I want to say this about Judge Glanville and his pride. I'm going to tell you now, I would have been found a way to recuse myself from a high profile case if I am not well versed enough to look competent at my job, as unbiased as reasonably expected for a judge to look, and all these things. I'm not staying where all these cameras gonna be watching me and scrutinizing me, and I don't even really know some of the basics that it seemed like these attorneys know that you should know. So that's where I'm like, okay, he has a lot of pride in a lot of different ways. Like, I don't know if he just thought, you know what, somebody kept saying it, and I'm gonna just have to go back to that. They said he probably has been used to just doing things his way, not being challenged, so he don't even realize he doing wrong half the time, because don't nobody challenge or say anything to him. So then you get in front of all these cameras, and now it's like, you're supposed to do this, you should not have done that, you were supposed to say this. Yeah. Shan said all this doesn't matter if she can be fair and impartial. Now that's true, Shan, but remember the whole thing is the what was it? The appearance of impropriety or something like that. That's the thing. Yeah, if she can, that's great. But I think the challenge is always the appearance of impartiality, impropriety, and all those things. Now they're gonna have to land on a judge. So I'm not saying she should also be recused. I'm not saying that. I'm just saying that those phrases can come up. I'll just say it. These judges have serious resumes, right? Glanville knows military code, not Georgia law. That's what I was thinking too, Shane. Like if you try to challenge him on some military code, military regs, and all this other stuff, he probably got you. But out here, it's I'm hearing that it's not looking that great. I mean, they just said it. That's how I'm hearing it. The pride wouldn't let them do it. How are judges elected in Georgia popular vote? I'm about to Google when I go back on mute. Good question. Because I mean, they say they over here donating to each other's campaigns and stuff. Bonnie said no one ever checked him. Okay, I'll play it. I'm gonna Google that too.
Appellate lawyer knows the law, so she's going to be very good on the law, and she's smart. So I think that she's going to be real good, and she's going to make sure she does things right. And it's going to be tough on this case because, frankly, there's almost no precedence for this type of case. I can't hear you, Peter.
Yeah, I know. I was talking to John.
Oh.
So again, the question that I asked was, that's who Woody pled to on this case. So how do you think that affects her ability to handle this case? And then we'll get to the second text. But I want to know specifically about these two texts, how you think this affects her ability to handle this case as the judge.
It's not going to have any impact on her. It happens all the time where they take a plea and the witness they take a plea with, that person becomes a witness. In fact, that's a regular case because, for instance, just give you an example, any multi-defendant case, you're going to have people that are going to flip in the case. And one judge is assigned to the whole case number. 3 defendants flip, they get a deal from the prosecutor's office to testify against the other defendants. It's the same trial. It happens during the middle of the trial. A defendant will flip during the 3rd day of the trial and become a witness on the 4th day of the trial. Well, it's the same judge. So there's no issue and there's no conflict. Happens all the time.
I just want to say thank you to IPV, but I'll also say thank you to y'all that have been, coming over here for the last few weeks about this trial. This is an intimidating one. It's big. It's like you're coming into something that's a criminal type trial. It's not where I had been used to going over. Mine was more reading over just some civil cases. So it is very intimidating to come over here and try to even make sense of what was going on. So I do want to say thank you to y'all that have come over here. And IPV, she said, hey, trending at some point in chat. I'm so glad you are covering this trial. It's a different perspective and I like it. This trial is definitely going to become a Tubi or Lifetime movie. I could see that. And thank you. Queen Common says not Glanville is a disgrace, in my opinion. He gave malignant narc vibes. Now I know not every military officer is the same, but Queen Common Sense, once they told me he had the military officer background, I said, oh, that's all I needed to know. Like, that's all I needed to know. That's where his characteristics show up to me. He's definitely one of those stereotypical, and I've only seen a little bit of him. I think if I had already been watching from the very, very beginning, I would feel even more strongly about some things with him, but I know I'm coming in the middle. Thank you, IPV. The way you've been covering has definitely spiked my interest back up. Ooh, you music to my ears, IPV. Thank you. Thank you.
Right. And judges are judges in front of lots of defendants over all these years, taking pleas from all sorts of defendants. It doesn't mean that any defendant that has ever been in front of a judge or taken a plea in front of the judge or been convicted in front of the judge can't become a witness in a totally different case, or in this case, it just doesn't matter. That's not a reason for recusal. And then the second part, which you kind of already mentioned, her appellate experience will be really good for a case like this and really good for the issues that we're already faced with. And the fact that she has the lowest case count in the courthouse and that she's efficient sounds great for like the least efficient and longest case of all time, right? That seems like a pretty good combination. One of the questions I had for you as well, based on this and with her appellate experience, knowing that she is going to be faced potentially with motions for mistrial, she's the one that's going to answer those questions. So what the heck does she have to do to prepare to be able to appropriately analyze and answer these questions?
Well, first of all, we know, she knows the pitfalls in granting a motion for mistrial. She knows you can't put it on the prosecutors, because if you put it on the prosecutors, it becomes double jeopardy, and it becomes with prejudice. So they can't be retried. So she's going to stay away from putting it on the prosecutors. She is great on the law. Those mistrials are really almost totally based on law. They're going to have to show some case law that requires it. Mistrials are rarely granted. I mean, I think you mentioned a while ago, there's probably been 100 motions for mistrial in this case already. That's the way it is in every case. You file a motion for mistrial, you preserve your issue for appeal, but there's, it's the odds in it being granted are slim and none, except the motion for mistrial for this case to start over again.
I share their thoughts on the fact that yes, if the one of the things that they point out is this judge being very efficient, and then like they said, this judge, not in a good way, I think, broke the record on how long it took to select a jury, and so it's gone on and on and on just from that alone. That would be nice if the case is going to continue and it's not going to be a mistrial. Get somebody efficient that's gonna get it done. So I do agree that that's a good pairing if she stays.
I think the odds are real good on that one.
So another thing that he posted here is join criminal defense leaders to reelect Judge Paige Reese Whitaker. Okay, so this is something that has come out that people are asking about, and then we look at this list and we see Brian Steele. I thought there was another lawyer on here. Isn't Ed Garland your buddy? Is that who you were saying?
Ed Garland's my buddy, yeah.
Yeah, okay. So you said you had a couple buddies on this list.
I do.
So we have this flyer here, okay? We've already talked about Glanville supporting one of the other judges. We don't know if Glanville did or didn't support this judge. I haven't seen anything like that yet. But when talking about reasons to recuse, or will the state try to recuse her or disqualify her, I should say, talk about how important or not important something like this would be, where criminal defense attorneys are supporting judges that end up practicing in front of them.
Well, first off, it's a good thing that criminal defense lawyers are actually supporting a judge. Here we have someone that's a chief of the appellate division in the prosecutor's office. Yet, defense lawyers think that she's fair enough that she would make a good judge. So it's a good thing for people to look and say, well, here's a prosecutor that defense lawyers think are fair. This is going to be a balanced person. That's the kind of person we want to sit on the bench. In fact, if you go down here, Peter, see Don Samuel down there?
Yeah.
We have his book.
Okay, before they talk about Don Samuel and his book, I wanted to say a couple things. First of all, DG, the only thing I could find is that the voting for the judges in Georgia are nonpartisan. That's what I could find. I don't know if it's just assumed that it is popular vote, because I couldn't get them to bring up any word about the popular vote, just that it was nonpartisan. Second, I agree with this. Military tribunals are very different, in my opinion, than civilian trials. His demeanor was more appropriate to a court-martial than this case. I want to go back and look at his demeanor a few times, but I agree he probably would look more comfortable and be more, probably just look like he fit into that, since that's where he came from. I have to go back and look at his demeanor a lot. But just the little I've seen, I'm trying not to say too much because I know I haven't seen it with my own eyes, and I'm forming an opinion based on everybody else's opinion. So I'm trying not to say too much more than what I actually saw, but I could see where y'all are coming from. And hey, cousins, I like that name. Let me see. I'm trying to. Oh, I want to tell y'all this, just because they're going through these judges right now. I had to look up how many judges were in the Fulton County Superior Court, and there's 20. I had to find out. So there's 20 judges of the Fulton County Superior Court. Just in case you're wondering, how many more judges could we go through?
In our library, he's the 11th. He wrote the book on the 11th Circuit case law. So Don's on there. I can tell you, those two that I personally know are tremendous lawyers. They're not going to endorse somebody that they think is a total jerk, but someone they think is fair. She must really have a reputation for fairness for these lawyers to be endorsing her. And so I think it's a good thing when people look for who they're going to vote for, any citizen. I think you should look for someone who's balanced, who has both the prosecutorial support and defense support, because then you know that that person's a balanced person. She was a good one. And by the way, she also was put up, she was on the short list for the Georgia Supreme Court not too long ago. she wasn't picked, but she was on the short list to move up to the Supreme Court.
Yeah, and that's what I'm saying. I think this is, we can go off on a tangent kind of, but like this is what you're looking for: somebody the defense attorneys like, someone the prosecutors like, somebody who was a prosecutor but they felt she was fair enough, or maybe because she did appeals, whatever it may be, that everybody likes her, and that's all great and good. This is never going to be a reason that a judge has to recuse herself in a criminal trial in a case, ever.
Never.
Or defense attorneys wouldn't support judges. Sometimes they donate, obviously if they give a judge $1 million maybe, but the $2,000 or $500 or whatever it may be that they donate to a campaign is never going to be the issue. And I will just say, we have supported a lot of judges in the past. Sometimes it's worked out well. Sometimes it hasn't. Sometimes we like doing it. Sometimes we don't. Sometimes it can get messy. And the judge is like, you supported this person and not that person. You supported the winner. You supported the loser. So there are issues with it when the lawyers get involved and do support judges, but it happens all the time. And there's actually a situation here in our jurisdiction where one of my buddies from law school tried to recuse a judge because a defense attorney supported that judge and lost. And it was a bad argument and it didn't go well. And I'll just kind of leave it at that because I really do like that guy that filed the motion that lost, but it is almost never a reason on its own to get booted from a case or not be able to try a case in front of a judge again, just because you supported them for judge or supported their campaign.
Okay. Look, we're learning something new. We are learning something new because the way they keep pointing out, they were not them, but people were making it seem like it's a big thing, but that does make sense. A defense attorney would never donate to anybody's campaign if that alone could, hurt a trial. So thank you. I'm glad they pointed out. I'm also like, DG said, I like how daddy attorney breaks everything down and is very direct. He should be on court TV. Ooh, okay. Shan says she's likely to grant a mistrial. Oh, okay. Hey, Cousins said, I'm trying to come out the bushes and join the chat, 41 Fit. Bonnie said, okay, she might be all right, y'all. We may have a judge that will stay and they can move forward. Yeah, well, that's good to know because they had me thinking the way they kept bringing up those campaign fund donations outside of these two attorneys, they just made it seem like that's the worst thing in the world to find out.
Well, it's only logical. I mean, who is going to fund or contribute to a judge's campaign other than lawyers? I mean, you think about it, they know the people the best. They know what the job entails. And so they're the logical people to do these contributions. Throughout the country, I don't know any jurisdiction that restricts lawyers from contributing or supporting to judges' elections.
And Thugger Daily said, if she wants a way to recuse herself off the case, she has multiple. I think, and this would be one of the situations where I actually think if she recused herself, it would seem even more fishy than the last judge, because these would seem like a reach because some other witness took a plea deal in front of her or because the defense attorneys supported her. I think she would have to have some other connection or something more than this to have an actual appropriate recusal of herself. Don't you think? Don't you think it would look like she was reaching for a reason not to have this case? Oh,
absolutely. And it would look kind of funny that one judge gets recused for cause, the second one resigns because, they find a way to resign. And then you got another judge who, I agree with you. I think that she's got to stay unless they can find something really concrete to kick her off.
Y'all, that is interesting to me. I'm not saying that she wants to get off the case. That's not what I'm saying, but I'm saying it's funny that they would start looking at her crazy if she comes up with a reason to recuse herself. Because our sister just got herself away from this craziness. The one before her. So I was just, y'all, it would be funny if they all kept finding reasons why they should be on the case. But he said they're going to start scrutinizing it if she. That's just funny to me. Oh, let me pop the trunk for Queen Common Sense. Thank you so much for the cash out.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Thank you very much. DG said, Daddy attorney is straight no chaser. He easily understood. He is easily understood by non-lawyers and very personable. He should have a court analysis show by himself. Son is okay too. I get what you mean, DG. The son, he has the dramatic flair. Like, hold on, Dad. Don't say that part yet. I'm coming to that part later. But Dad is like, cut through it. She found a reason to get her butt off this case. We know what it is. So I totally understand what you're saying, DG. Limited time. Let us understand what's going on. Boom, 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 boom. And they are great together as well. But if you want it real quick, like the dad's getting to the point. Queen Common Sense said, I suspect that there is a bit of hype behind all this in an attempt to divert the attention away from, Glanville's behavior. Maybe. I wonder who's on his side to help him divert too, though. You know what I mean? Because it seemed like, I don't know. I wonder how the media feels towards Glanville, because I know the prosecution obviously likes him. And Bonnie said, I hope she don't try right. She's efficient. Please stay and just get this one done. Queen Constance, I think I'm going to change the spelling of my name. Everyone uses a K instead of a Q. Oh my gosh, I did it too. And I double checked myself and still put that doggone K. I swear I double checked myself. DG says sometimes attorneys, judges shop, which is improper, looking for a judge that is perceived as being more beneficial to their position. Yep, I agree. This is probably doesn't say too much, but DG, I used to read the mess out of some what's the one author? Is it John Grisham? Is it John? Hold on. Is that his name? I'm gonna find his name. Is he an author too? Yeah, because he was a lawyer, right? And he wrote all the greatest, some of the greatest dramatic fictional legal books and stuff. I read the mess out of some John Grisham, and I was like, that ain't coming from nowhere, DG. So I totally agree with you about the attorney shopping around for judges and all these things. Like I agree with you. 41 said, thanks for your generosity, Queen. They would be a great team with their own show. Yeah, honestly though, let me tell you what, when YouTubers sometimes go from YouTube to a structured show, the people take away their magic that they had on YouTube. That's the only thing I don't like. Like if you have faith in them enough to get their own show, people that produce it, people that fund it, don't take their magic away. Let them be them, because that's why people like them while they were popular on YouTube. I'm going to ask Mel if we can have them on Nubian TV. Oh, can we get a court TV section on Nubian TV, DG? A true crime court TV type section would be awesome. Some type of For My Man and not just them, but you know what I mean, DG. All the things. Follow the big trials. DG, that would be a great thing. I love that. Shan said, I disagree in the hype aspect. This case has been getting more and more popular because of the witnesses. Maybe more and more popular because of the witnesses, but Young Thug is a huge name out here, although like I sideline know about him, but just him alone, it is a lot of like, I don't know. Like I see what you're saying, Shan, because you probably was there from day one, but I don't know. But I also don't know if they're trying to hype up anything to take away from Glanville. That part I could see, maybe not. But I was gonna say just the hype in general. That's why to me it's called the Young Thug trial, because they're making it the Big Fish name, although it's more about YSL in general and Rico. He don't even have all the counts against him. 41 Fifth says she'd love to see it. Okay, let's keep going.
I agree. And I think that also you said she was on the short list for the Georgia Supreme Court, which I didn't know, but as hard as this case is, as miserable as this case is, if you come in and you do a really good job, and right now the bar is not set very high, maybe that would propel you to be not just on the short list, but someone who becomes a Supreme Court justice in Georgia, right? This could be a career advancement for her if she handles it appropriately, shows how fair she is to both sides, and moves the case forward appropriately, don't you think?
Oh, absolutely. And she wants it because she applied for it once. So she wants to move up. So I think you're right. And let's face it, it's a smelly case. It's a high-profile case that's a mess. if she comes in, cleans it all up, and ends up with a fair trial that gets upheld on appeal, she is going to look great. Her profile is going to be high, and she'll be a logical choice.
Yeah, and that's what I'm saying. And there's nothing wrong with that, right? I mean, people are going to say, "Oh, it's so bad," but it's like, no, this case sucks. This case sucks to be the judge of this case. And you know where it sucks even worse? Now, to come in and clean up the mess. It would have been one thing if you were the first judge on it and you could have done it your way, but to come in now is infinitely harder to get this thing back on track. And if she's able to do it, kudos to her. Sandy asked, if they declare a mistrial, would it be better to split up the defendants? Could that shorten the trial? So what are your thoughts on that? I have some thoughts on that, but what are your thoughts on that?
Well, it wouldn't shorten the trial because if you split the defendants up, that means you have two trials. You have to pick two juries and you have to present the witnesses twice. So it's not going to shorten things up in the long run. It would not be judicially cost efficient to do that. It is very difficult to try multi-defendant cases. I've prosecuted them and I've defended them, and it's really hard. It's very hard for the judge, but it is cost efficient to try them all together. So I don't think they're going to split them up.
In your opinion, who usually pushes more to sever cases?
The defense.
Yeah. So that's what I was going to say. Like, as far as the prosecutor goes, usually they just want to go. And the reason that they'll argue is exactly the opposite here, Sandy. I get what you're saying. And based on this case, I get why you feel that way. But most of the time, prosecutors say it's infinitely faster to try them all together because we got to call all the same witnesses now 6 different times. We got to get Woody on the stand 6 different times. We got to get this person there. We got to get this cop on the stand. And we can't testify to this in this trial because it touches that guy, whatever it may be. So the prosecutors usually push and say it's infinitely easier to do all this together. Doesn't seem or feel that way here. But the defense attorneys usually want to sever, which is also interesting because now it almost seems like the defense attorneys are a team. And even though they represent their individual defendants, when something like this happens where the judge screws everybody or the prosecutor screws everybody, they get on the same team and fight them together.
And again, she is the kind of, I really believe they picked a good one here. It was the wheel and it was a random choice, but she's also got a lot of good experience. And she's also, Peter, you and I know this and your listeners, but she's a member of 2 ends of court up in Atlanta. So she is a person that mixes well with the private lawyers. She goes out socially. They have dinner together. So, they know her, she knows them. So it'll be a congenial atmosphere in the courtroom. That makes for congeniality. That's what ends of court do. That's the idea of it's kind of a club that professes that. She was also on the board of governors for the state bar of Georgia. So she is very active in the bar and very active. So she's a well-known person, well-known face, and she's out there socially and gets along with people. And that kind of person tends to give you a fair trial because you really, if they're a nice person and you get along with them and you know them and you have dinner with them at meetings, it's not the kind of person you yell and scream at and make accusations that you really can't prove.
Right. And I mean, when you talk about, you have to be careful when you talk about having dinner with defense attorneys and mixing it up with them. These are like that bit. These are like, there's 50 people there and you split off into 10 groups of 5 and each group does a presentation and you pick a part of a trial or whatever it may be. And everybody works together and there's usually one judge in each group. So we get to know the judges present to, they're just one of us common folk in these, ends of court meetings. And it's really cool. And it's a really good way to get to know judges. It's a really good way for young lawyers to get to know judges and have the opportunity to learn from them. And not every judge does it. So the fact that she's in 2, I agree with you, really shows well for her. Traveling Teresa said, can we address the prosecution misconduct? Do they just get off scot-free? So even if she does not grant a mistrial, or if she does grant a mistrial and doesn't blame it on the prosecution, there are still arguments the defense can make against the prosecution.
Right. They still can make it, but I don't know if they're going to be successful after that order that was written saying that there was nothing wrong with the meeting. So I don't know now. I believe, and I'm not sure we know who, but hasn't somebody filed a bar grievance against Love?
I have no idea.
I heard that, but I know that people have denied it. Who they said, have you filed it? No, I'm not the one that filed it. But there's still the possibility that there could be bar discipline for the actions that the prosecutors took.
Yeah, and we'll see. Bodie said, does it matter if the defense likes her? So, and that's also kind of a misconception, I think, too. It's a good question, Bodie. I appreciate you asking. But us liking a judge. I have lost, and you have lost, plenty of cases in front of judges that we're friends with or friendly with or like or respect. Just because we like a judge or respect a judge or think a judge is fair doesn't mean they go in and just do whatever we ask. It doesn't mean we win every case in front of that judge. It just means we're going to get a fair shake. And that's really all we care about as criminal defense attorneys. We lose more than we win as criminal defense attorneys. That's just kind of how it is, because the prosecutors have all the resources, all the money, all the time, all the power. They choose which cases they want to take. They choose which ones they don't. And, that's just kind of how it is. So, does it matter if the defense likes her? Yes, because that usually would mean she's fair.
Yeah, well, and that's the point. That's all. You're right. All you can ask for is a fair trial. That really is all you can ask for. And one of the things, you mentioned it just now in your list, the prosecutors pick the cases they try.
Okay, before we get into the prosecutors picking the case that they try, because that is so true. DG, now in my head, instead of pronouncing it daddy attorney, in my head, I see daddy addy now. So I'm going to read it how I see it. So the way I see your comment, I said that too, daddy addy. I said it needs to be change of judge, venue, and prosecution team, and jury at this point. I definitely agree with the change of prosecution team too. And of course, I will lean towards y'all, you that have the great legal expertise, that if you say it also needs a change of venue and jury, then that's what it needs too. Thank you, Queen Common Sense. Thank you. Okay, I'll keep going.
Remember, if it's a bad case and they think they're going to lose, they don't charge it. So you only are going to go to trial on cases they already have decided they think they can win. Otherwise, they wouldn't have charged the case.
Nick said, Attorney Harvey asked to sever the case for his client since pretrial. Mr. Nichols is only mentioned twice in the entire indictment. Yeah, and that's the other problem, is you just have these windfall verdicts where it's like, we're just going to convict everybody because we think, Young Thug or just one person did something or was really the king of this, and everybody's guilty by association. That's a major problem in these multi-defendant trials as well.
Right. But I've got to be honest with you, the jurors surprise me sometimes. They surprise me a lot, in that you will find in these large trials, they'll find 20 people guilty and then 1 or 2 people not guilty. So jurors really take their job seriously in most cases, I think. And they will go through each individual defendant and the evidence against that defendant. And like I said, I've been surprised at how good they do.
Yeah, and I don't mean to say that they're not fair. I mean to say that once you start thinking the criminal activity is being done by the criminals in the courtroom, sometimes it's hard to separate and just pull one out. Not to say it can't happen.
Right. There's
it's
a
harder than
spillover.
if that person was being tried individually, I think.
Yeah, there's a spillover effect.
Unknown Me said, since Whitaker is the judge, how long do you think it will take for court to resume? Well, we hear there's a hearing tomorrow, but after that, for actual trial to resume, I have no idea. What's your thought?
Well, resume is a really broad term. I don't know what resume really means in this case, because I don't know.
Okay, y'all, that's most questions that were asked in the beginning. I don't know, Sweet Jane, if you're still in here. I know you were asking that. CC may have asked that. Someone else did, about when does trial resume. So they don't even know. They're not sure. We just know we got this third judge. So, okay. So, cause I was like, I don't know, unless they put a date out here. I have no idea. So, they're waiting too. And like a true attorney, like a true lawyer, they're like, what does it mean by resume?
If she is going to start in the middle of the trial, which again, there's no precedent. I couldn't find a case in Georgia where this kind of thing happened in the middle of a long trial like this. The theory is you can read the transcript to catch up, but who's going to read 6 months worth of transcript? There's got to be a good 10,000 pages. My guess is resume is going to mean she's going to hear the motions for mistrial. She's going to rule on them. Again, I'm going to make a prediction. She's going to grant them without prejudice so that the case can be tried again, and they're going to start from the beginning.
Yeah, I have no idea. I have no idea when it's going to resume. I hope sooner rather than later, but I hope she doesn't rush it. I hope she does, do her due diligence and doing all the background on the case so she knows what's going on, knows what the priorities are. I'm sure she will. Azam said, I missed wishing you yesterday. Happy belated birthday, Papa Tragos. Happy anniversary to you and Whit. Peter, thanks for spending time with us. Thank you, Azam, for
Also, she might decide that it's going to be pretty far in advance because you're going to have to find, 10 months worth of trial date. She might decide that it would be unfair to keep these people in prison all this time, or in jail. Actually, it's not prison. To keep them in the county jail all
I
this
think
time.
you might be giving her
You
a
may-
little too much. I would be shocked if there were bonds. I've
might
been wrong
be.
before, right? I've been wrong before, and you've handled a million more criminal cases than I have. But with these charges, with witnesses saying they're in fear for their life, with connections to the outside world and gang activity, which they've been accused of, I would be really surprised if they were handing out bonds, unless there's somebody that's like very minutely involved that's still sitting in jail right now that I don't know about.
What about the guy you just talked about? He's mentioned like twice in the indictment,
Yeah,
minor
I don't
player.
know. I don't know specifically what they're talking
I
about.
mean, I know, but I think there's some chance of that. They've got good arguments for a bond.
What typically happens after a status hearing? I mean, this is not a typical status hearing, but the case usually moves forward and they decide what's going to happen next, maybe some scheduling, what's the status of what's going on. I mean, there's just a million things going on in this case, so it's not going to be like your average status hearing. Do you think Ashley Merchant can step in regarding the prosecutorial misconduct? Mixed Chick Samantha asked. I don't know how she would step in on the prosecutorial misconduct. It would be the lawyers who are representing the defendants in this case. She represented Brian Steele. I don't think that would come into play here in this trial as far as getting it dismissed unless they hire her on. One of these defendants hires her to be one of their lawyers. Additionally, I don't see how she would affect that. All right, let me see if there is anything else. All right, so we're going to call it here because at 3:30 in about 2 minutes, if you have the auto play button.
Okay, they're done then. They're done. Okay, so that was good. Now we're caught up to our third judge, Judge Whitaker, who is thought to be efficient and fair. We're waiting to see if this is going to be a mistrial. We're waiting to see how she chooses to continue. So we have some things, and they said, oh my gosh, what did they just call it? Tomorrow at 11:30. I don't know if that's Eastern Standard Time or not, but there is a status hearing, I believe. I think that's what it was called for this trial. So, y'all can catch that. We'll catch up with our daddy Addie and the lawyer, to see what their thoughts are after the status hearing. At some point, we'll catch up with that. Tomorrow, we're going over Kevin Hart. Well, Kevin Hart's friend suing him over that SCX tape extortion. We're gonna read that lawsuit, and it may be some other stuff, but I know that for sure. I need to hold myself accountable and do some of my property preservation tasks that I have for class. So I probably won't be live as often as I was last weekend because I know what I'm supposed to be doing, and I think I'm procrastinating just a little bit because ish is getting real. So I need to take care of some things. DG says Shan, fresh set of eyes will cut the BS charges and try just what's needed to get a verdict. Rico is a reach, in my opinion, but I don't know Georgia law. Oh, Rico's a reach. Okay. All right, y'all. Well, I will see y'all tomorrow for Lunch Break Live. I enjoyed you. Hope y'all have a great rest of your day. Shout out to my replay gang later on. And I'll see y'all tomorrow. Bye.
I've been taking my time,